Mema obi biara akwa aba biem ba Odinhu TV eso onya subscribe a mesrɛ na wa subscribe na wa like na wa share video wi ama wonua no so enye bi ahwena bibia etimi akoyi ama na busua yɛfa ni embo ransem an sɛ Professor Bafo Agyemang na wetimi de nsɛm ahoro na ato amane John Dramani Mahama a enye asamketo akra na ɔkyerɛ sɛ John Dramani Mahama no ɛwɔ sɛ ɔsan kɔ back na okosua bibi kakra efi Ekufu ado honum a na kyerɛ sɛ enye asamketo ɔkyerɛ sɛ ntino ɔsan kɔgye ntete a na kyerɛ sɛ obetimi de ebu ɔman Ghana a na kyerɛ sɛ ɔnkɔ na ɔnkosua sɛdeɛ Ekufu ado ebu ɔman Ghana no ɔnkɔ no nkosua no na ɔno nso ɛmfa bedi ne dwuma ɛno ɛho nsɛnsɛm aba betu dwa na ɔkyerɛ sɛ nti petition a otimi edi Torkonu efi office no enye petition papa bi a wɔsɛ ankogina so edi eyi no nanso no wetimi eyi no dia ende na ɔwɔ call back na okosua bibi na Ekufu ado enso ɛwɔ aban mu no saa pepepe na nkrɔfo edi petitions ahoro na ebrɛ no sɛ ɔmfa yi ne chief of staff executive ne nkrɔfo bebre na nanso no wentimi anyɛ saa de no ɔtɛne nsɛm no upside down ana kyerɛ sɛ no so ɛboa yɛ ma na memo ɛkɔɔ so nti ɛbɛyɛ a ɔno so no ɔnyɛ ne saa pepepe nanso no ɛtimi enya eyi no efi hɔnom dia na ɛwɔ sɛ ɔpɛ bibi ɛfa ho na me nsɛ wɔn no yɛnkɔ gye ne ho ne nsɛm no emu nkyerɛ mu meda wase.
There are certain aspects that I think is of interest to all of us. You look at governance generally, and I think my friend Yusa alluded to that. We have three important legs in governance. We all know that. The legislature, the executive, the judiciary. And for the sake of accountability, we go by this theory of separation of powers, which we try to actualize in governance. And also, we have this notion of the independence of the three entities. So my interest here is within the context of that, the governance. Where are we going with this particular case? First, let me take the notion of the separation of powers. Whether this particular incident breaches that notion is of interest to me. Because if that notion is breached needlessly, it creates a crisis for governance. Not only that, as a fledgling democracy, it also gives some very wrong signals to ourselves as aspiring Democrats and to the world out there. And I've had the issue of the use of discretion or making decisions. Let's not forget that this is not the first instance petition has been made. At least in my lifetime, I won't go far into history, but the petition that removed Charlotte Osei.
And her two deputies.
And her two deputies. From what we know, that petition was submitted by one individual. As I sit here, I don't even know the name of the person. And we're told at the time when issues were raised by the president.
I think it was submitted by a number of individuals. Began with a nameless individual.
Nameless. So how many in all? Do you know how many people were involved in that petition?
It was a couple of people, I think.
Okay, let's say a couple of people. And the president told the country that he was simply a conveyor belt, suggesting that perhaps he did not even review the petition and simply submitted it. So the process went on, and we know the outcome. That, in retrospect, could have been a very bad decision on the part of the president, setting a bad precedent, I should say. Not that citizens don't have the right to petition, but I think when you are dealing with a position as important as Chief Justice, I'm skipping from the Electoral Commission side, I think there must be serious introspection. Again, because of the issue of separation of powers here. And if you go into history, there are instances where presidents have been very angry with Chief Justices. And if you look at how they have dealt with them, it gives you some guidance. Because in a democracy, the last thing you want to see is for the executive behaving in any way as to undermine the other branch of government, in this case, the judiciary. So presidents have been very circumspect. In fact, they've constrained themselves.
What's the point? The petitioners bring petition. The Jubilee House should refuse them or receive them and trash them or what?
As it is, you got to follow the process. That's why I enjoyed the presentation by Inusa. The process, our constitution as it is, you have no other option but to proceed with the process, except to say that when it's submitted to the president can decide to move it forward or not to move forward. I think towards the elections, there was one petition that was submitted to the president, Akufo-Addo. We all saw the response he gave, apparently claiming that there was no prima facie case there.
Together with the Council of State.
Exactly.
And Uncle Sam Okujeto has been speaking about it. They considered it and found that there was no merit in it.
Exactly. So that was one way. Perhaps it was an option to avoid this interference in this separation of power notion. But in this case, the president had decided otherwise, and you cannot fault him because he's following the process.
Is it the president who has decided?
Well, it was first submitted to him, wasn't it?
Correct.
Did he review it himself?
Prima facie, according to the Constitution, is done by
the Council of State.
Acting in consultation with the president.
So the president saw it. And he could have decided
that
perhaps it is not worth proceeding.
So he does what with it?
Pardon?
So he does what with it?
If he decides it's not worth, as Akufo-Addo did, he could have also written to say, look, I receive it, but it's not worth. Or is the president obliged to proceed by all means? I guess, again, you are the lawyers. Let me understand. I guess what I'm trying to say is that the central point here is that it's always important to protect that principle of separation of powers, the independence of the three entities. That's the essence of my discussion here. So unless...
Hold on for a minute. Okay. Oliver, can you help him out with what he's sort of seeking a response to about what the president...
If even these matters were acceptable to be put in the public domain, custody issues will come up. Where is she getting it from? Evidence in custody. Where is she getting it from?
She had actually said that leakage of the petition by some government officials. It was one of the questions I was going to ask her to show which government official she's referring to. And my viewers and listeners, this is what I do. Once you make allegation, I hold you to prove the allegation. And sometimes, you know, the partisanship of how you view the things, you say, why are you doing this? But I have to do it. Even if I have seen one, I still need the person to prove them. Okay, so, yes.
So, for me, we can continue talking about what this conversation is about. But my position is that there's good reason why Article 146 is in our Constitution. It is to ensure judicial accountability. And there's also good reason why you need a judicial tribunal as advised in the 1969 Constitution, which in the 1992 Constitution is a tribunal to determine whether there's a prima facie case. I mean, why you need a Council of State acting in consultation with the President to determine a prima facie case, and you need a judicial tribunal to subject the person, or the respondent, to trial. And the respondent must be given all opportunity under Article 146 to defend himself or herself. So the fidelity of the process is what we should be concerned with. Whether the rights, and I see a lot of rights, I also see a lot of constitutionalism embedded in Article 146. I mean, any day I look at the Constitution,